the owners claimed that the downstream flooding was caused by permits that were issued by the Water Management District. The court on appeal said that an inverse condemnation claim is not barred by a legislative grant of immunity. So even though the Southwest Florida Water Management District has statutory immunity, or it may be authorized by statute to issue permits, that those permits and that immunity do not trump the constitutional right to compensation. And essentially the court said that the trial court erred when it dismissed the claim for inverse condemnation based on sovereign immunity. The next case, and the third seminal case that I want to talk about this morning, is St. Johns River Water Management District versus Coons. This is a case where the Florida Supreme Court has granted certiorari about 2 weeks ago, and this case is currently being briefed to the Florida Supreme Court. This is a case where this is actually the fourth time that this case has been on appeal. The owners actually started litigating this case on appeal, I think, in 1992, or 1994, when they initially sought a permit to develop their property for a higher commercial use than what was currently allowed. The owners had had previous taking from their property, and their property acreage had been reduced, so they had less property to work with, but tried to have an increased intensity of commercial use on their property, and applied to the Water Management District for a permit to do that. The Water Management District said, well, we'll grant the permit, but we want you to do what's called off-site mitigation. We're not requiring you to dedicate property, like what happened in the New Testament case, but we want you to do an act, provide an act of service for us. And what we want you to do is some off-site mitigation. We want you to install some culverts, some drainage culverts in some property that's maybe 7 miles away, and we want you to provide just some wetlands in an area that's also several miles away. And under those conditions, we'll grant the permit. Well, the owner rejected the permit offer, did not agree with the conditions, and the permit was then denied by the Water Management District. The case went on trial, and the trial court said that there was a taking. The trial court said that there was no essential nexus between the conditions to the permit, and there was no rough proportionality between the degree of the required off-site mitigation or wetlands mitigation and the use that was going to be made on the property. To me, the most important component of this decision is that the district did not challenge the factual findings of the trial court. The district did not dispute that there was no essential nexus and that there was no rough proportionality. Instead, the districts argued, well, if you want to, what you're really doing here is you're challenging the denial of a permit. And challenging the denial of a permit requires you to go under an administrative procedure, not a condemnation procedure. And in this, in the trial court disagreed, and the appellate court disagreed. But what's unique about this decision is that you have an appellate panel of 3 judges, and you have 3 different opinions on this case. You have a majority opinion, you have a concurring opinion, and then you have a dissenting opinion. So each judge wanted to be heard on this decision. The court essentially found that there is an exaction claim where an owner refuses to agree to permit conditions. So if those conditions are constitutionally unreasonable. The district argued, well, how can there be a taking? The owner hasn't agreed to the permit conditions and hasn't been required to give up anything. So how can there be a taking? And on appeal, the appellate court found that a claim for an exaction arises where the government attempts to request unconstitutional conditions, essentially saying that an attempt by the government to extort is no less reprehensible than actually accomplishing that. What's interesting, too, about the decision and the question that the Florida Supreme Court will be hearing is whether or not a taking occurs for what's called a non-dedicatory exaction, or an exaction or condition of development approval that does not require the dedication of land, but requires an act of service or payment of money, something of that nature, besides the conveyance of property. And the certified question is that where the landowner concedes the permit denial did not deprive him of all use, but you have an exaction taken under Nolan and Dolan, is the compelled dedication of real property, to public use, instead of a compelled dedication of real property to public use, in other words, a non-dedicatory exaction, does that exaction as a condition for permit approval So that is, again, currently being briefed and will be a major decision by the Florida Supreme Court hopefully within the next year. I will tell you that the State Supreme Court of Texas has decided that a non-dedicatory exaction does constitute a taking, and that in its decision it has cited Florida United States Supreme Court authority to make that argument. So it'll be interesting to see how the Florida Supreme Court decides that issue. Another case to talk about is Collins versus Monroe County. This is one of two cases that I'll try and briefly go over that talk about a unique provision in Monroe County and the city of Marathon dealing with what's called a beneficial use determination. The code for a beneficial use determination required an applicant to demonstrate that they could not make any beneficial use of their property because of the application of land use regulations or the comprehensive plan. And if that beneficial use determination was made by the staff and the county approved the recommendation of the staff saying that you could not make any use of your property, the county would then, or the city would proceed to take the property or purchase the property from the owner. In this case, the first case we have on this issue, Collins versus Monroe County, you have 16 people, one company, and one PA that were all part of this appeal. So you have a total of 18 entities that were all represented as property owners, and the county on the case. And the trial court had held that a facial taking occurred. In other words, a taking occurred by the mere enactment of a regulation back in 1997. And that because you brought this lawsuit beyond the 4-year statute of limitations for inverse condemnation, your claim was barred. And this decision by the trial court was against the argument that was being made by the owner. And the owner argued, the owners in this case, argued that a taking didn't occur until we received the beneficial use determination, which did not occur until 2002. What's interesting too about the history of this case is that the trial judge initially assigned to the case said, yes, we agree that, I agree that if the taking occurred here was an as-applied taking, in other words, a taking that occurred when you received that beneficial use determination. That trial judge then was rotated off the case, and you had a successor judge come on board, and the successor judge reversed the decision of the trial judge and said, no, you have a facial taking that occurred here, so your claim is time barred under the statute of limitations. So the owners were then forced to appeal that decision, barring their claim. The court takes the opportunity, the third DCA takes the opportunity here to announce some general principles of law, that a facial taking does not occur when you have the enactment of a regulation or a law that does not deprive the owner of all reasonable economic use. The court went on to say that here, the owners were not deprived of all reasonable economic use, where they received compensation through the sale of property or building permits to develop that property. So in this case, some owners were actually able to sell their property, even